Thank you. May I have a seat? Madam Clerk.
Appellate case number 2023-001082, Town of Sullivan's Island versus Nathan Bluestein.
Thank you. Mr. Hood, Mr. Wilkins, good to see everyone today. Good. Mr. Hood.
Good morning, Jamie Hood on behalf of the appellants. In 1991, the Town of Sullivan's Island properly executed its proprietary function in entering into a two-step land deal. That land deal was to sell the accreted land on Sullivan's Island to the Low Country Open Land Trust for the stated purpose of encumbering the property with restrictive covenants. And step two was for the Town of Sullivan's Island to retake the property in that transaction, which it did. The purpose of this was to ensure that the accreted land and the protection afforded to it under the restrictive covenants would not be subject to the whims of subsequent town council. So they used our property laws and our property rights as a mechanism to do that, which I believe was effective and valid. I'm not suggesting otherwise. In that same transaction, the restrictive covenants provided my clients with standing to enforce the provisions of those covenants, one of which we maintained in an underlying lawsuit was that the Town of Sullivan's Island had a duty and obligation under the restrictive covenants to maintain the accreted land. We contended that they failed to do so. We brought suit challenging them for failing to live up to their obligations under these restrictive covenants. That lawsuit was tossed for summary judgment, came here before the Court of Appeals, where it was, summary judgment was affirmed. Then I was at the Supreme Court, which reversed the Court of Appeals, remanded the case back down to the trial court for the purpose of addressing the ambiguity found by the Supreme Court in the restrictive covenants about the Town of Sullivan's Island's duties to maintain their property.
Let me ask you, Mr.
Yes,
Hood,
sir.
under this agreement, would you concede that if the town's responsibilities under this agreement, that if it is in fact a legislative function, then it should be, the judge was correct in her ruling?
I would agree so far as that if the transaction did in fact and was in fact a legislative governmental function, then the analysis would come forward under Cowart, and you would look at what the provisions were within that to determine whether it was or was not enforceable. And the reason I say that is because there is a severability clause, and some of the offensive language that the trial court found could be dealt with, and I think we'll get to that momentarily.
Assuming the severability clause is not enforceable, would the trial judge be correct in her ruling?
I mean, you're asking, I just fundamentally disagree.
So I guess, let me just,
Okay.
assuming, obviously you don't believe that the town's functions under this agreement are legislative?
Correct.
Okay, so that's why,
That's correct. And so when we entered into the settlement agreement was negotiated by outside counsel for the town's counsel, and their own internal attorney. We all agreed collectively on the settlement agreement, presented it, the town council voted on it, approved it, and made findings of fact consistent with the deed restrictions, including that it was fair and reasonable and appropriate at the given time.
but it's of no import that the citizens get to mutually agree with subsequent cuttings, or in essence, the town has to seek the approval from your clients.
It says there's flexibility built in there for discretionary cutting after, I think it says.
The initial.
Periodic terms, and then it says parenthetical, 5 years is what it says there. It's subject to approval by the town's naturalist and to address any changes. It was designed and created to create flexibility for the town at the expense of the people who would like to have it cut, not the town. And so the problem that I have with the analysis is that it is okay to buy and purchase land under your proprietary function, but it's not okay to agree to maintain it under your proprietary function. I think it's illogical And I think a conclusion that determines that maintenance of your property as you're obligated to do it by the restrictive covenants that you negotiated to put on it and then purchased it back, if you can't do that as part of your proprietary function, then you can't put restrictive covenants. You can't put historic easements. You can't encumber property in the future. And I actually look at the Cowart case in footnote number 5 at the end of it, where it talks about how do we figure out what's proprietary and what's not. And I found it interesting. It describes proprietary function. This was talking about the perpetual succession issue. But in the footnote, it mentions holding property as a proprietary function. I believe that it's self-evident that a municipality can own property, and it does not do so as part of its governmental function, but as a proprietary function. And that's the genesis for the settlement agreement. Otherwise, Your Honor, I don't think the Supreme Court would ever send us back. I think the Supreme Court would have said, you filed a lawsuit and you can get no remedy.
Is it of any import that the duration of the execution of this agreement is in perpetuity
I disagree with that assertion.
and binding on subsequent or successor councils?
Let me just address your question by saying there are 3 different time parameters in there. First is zone number 1, which is with all due haste. There's nothing perpetual about that. Number 2 is the next block within 1 year. Talks about the funding. Those 2 are within a single year period, very finite. The third area talks about periodic adjustment that we just addressed a moment ago. Does that bind future town councils? Only in accordance with the terms of the settlement agreement. But it lasts as long as the town owns the property and as long as the covenants run. The covenants are almost finished, actually. They're a 50-year covenant. Now, it's up to the town what they're going to do with it. But in 1991, the agreed-upon term, which was valid, was 50 years. And so this agreement will last with the town while it owns it during the period for which the covenants exist.
So the mutual consent that is necessary from the landowners does not impair the council's authority in any way, as you understand it?
It doesn't. I think the settlement agreement says the town has the absolute right to manage that was part of the negotiated part, that we gave up this idea that the town had complete discretion to do what it wanted, because in the underlying case, our position was that the restrictive covenants told us what it had to be. And that was the condition as it existed in 1991. And so we gave that up to allow the town to control it, taking the position that it had unfettered discretion over that.
I'm confused because in one hand, you say that the landowners have no say-so in how that's going to be done, how the trimming and maintenance is going to be done. But on the other hand, the agreement clearly says that they have an opportunity to be heard and their opinions respected and considered in that process.
Right.
Can they stop it? Could they say, no, you can't do that?
I don't think so if that's an unreasonable withholding of consent. It says in the settlement agreement, reasonable consent will not be withheld. So the idea was to create the flexibility that if the town wanted to take more aggressive cutting measures, you may say, that they could come back and have a conversation about that. If they chose not to, they could have a conversation about it.
And what happens if they can't agree?
If they can't agree, then it would be up to the property owner to come back to the court and try to enforce it. So when you look at the sort of the history of it, it's just hard to imagine that a party or parties litigation can engage in litigation for 10 years, can go to a Supreme Court, can come back down on a remanded case after being encouraged to try to settle it and spend a lot of time working and settling it, and then take all of the steps needed to get the settlement agreement in place and then begin the implementation process through the permitting effort. And then we came back to the court with an amended agreement demonstrating everyone's good faith because it required permitting and the circumstances changed because it's a fluid situation. And at no point in time did this issue of whether it's enforceable as a governmental function come up until there was a subsequent election. And there's a new town council, and they advocated for it, and they began a campaign to undo what had already been done. And I don't believe that from a judicial economy standpoint, from a municipal governance standpoint, that you should be able to enter into a settlement agreement that is a contract that talks about your obligations to maintain land that you own that is subject to covenants, and then walk away from it by virtue of an election. It stands to reason that what we're seeing here is not a governmental function, it's a political function. It's politics entering into property. And so when we negotiated the contract, we're dealing with property rights. The briefing talks about zoning. For 10 years, I fought zoning until I got to the Supreme Court. And they recognize this is not a zoning issue. This is a deed enforcement issue. And that's where we are. So we have deeds. And the benefit that the town obtained by this settlement was that they were able to control the timing, they controlled the mechanism, they were control the process, they were control the naturalist, they control the vendor. All of that is town controlled by them, as opposed to an independent person at trial, and they avoided potentially millions of dollars in loss of value. So it was a tremendous advantage to the town of Sullivan's Island. I see my time is up.
We'll hear from you in reply. Thank
thank
you
you.
so much, Mr. Hood. Mr. Wilkins.
May it please the court.
Yes, sir.
This case is not about restrictive covenants. It's about the settlement agreement. And on page 14 of the appellant's brief, they write, under the legal principle as stated in Coward, the settlement agreement would not be binding on a successor town council if the subject matter of the agreement involved legislative functions or governmental powers. So if the settlement agreement it does in fact involve and was approved pursuant to governmental powers, the appellates concede that it is unenforceable. A new council was elected in 2019, and they approved and passed by resolution the appellant's settlement agreement. In 2021, a new council was elected, and this council concluded that the settlement agreement was a misuse of that prior council's legislative governmental powers. Therefore, it was void and unenforceable. Government functions or government powers, sometimes referred to as legislative or police powers, involve matters concerning three things: the health, the safety, and the general welfare of the town, its residents, and the public at large. These powers give a town council the ability to enact ordinances, resolutions, determine the best use of government property, hire individuals who work for the town, levy taxes, prepare a budget, and spend the tax dollars. Our Supreme Court and this court has consistently held that a prior council may not tell a future council what it must do or what it may not do regarding the exercise of its governmental powers. A prior council may not restrict or impair in any way a succeeding council regarding the use of these powers. In the Coward case, this court instructed that an act of a town council is one involving the exercises of governmental powers is dependent upon the subject matter of the contract at issue. And of course, the contract in this case is a settlement agreement, and we determine what the subject matter is of the contract from reading the words written in the contract.
Is there any merit to the severability argument?
To the what, Your Honor?
Is there any merit to the severability argument?
No, sir, there's no merit to that because this agreement, this settlement agreement was void ab initio. It was void from the moment that the council passed that resolution. But if you want to apply that principle of severability, sever the bad things out of this contract, you won't have anything left. I say it's not applicable, but if it is, it won't make any difference. The actual words of this contract, and let me just give you, court, just a few examples. There are many others. Paragraph 2 of the settlement agreement reads as follows, and I quote, "The settlement and implementing steps associated therewith are necessary for the health, the safety, and the welfare of the town." These are the three basic reasons the town council exercises its governmental powers. The settlement agreement also provides primary funding for the transition zone work will be from the town. Thus, this prior council is attempting to dictate to future councils how it must spend taxpayer dollars of some undetermined amount. Without question, this is impairment of governmental powers. The settlement agreement provides current town procedures will apply for annual cutting and payment thereof will apply. So this prior council is attempting to freeze its current procedures so they will always apply in the future to all succeeding councils, something it simply cannot do. The town will engage an engineer, and I quote, an engineer and/or a technical consultant. The work shall be done by way of a contract signed by the town, and a vegetation management contractor must also agree. Again, attempts to impair the use of governmental powers of future councils by dictating to all future councils whom it must hire and how they're going to be paid.
Mr. Wilkins, if I might interject, isn't part of that, could what you just described, could not that be deemed proprietary or business in the sense that the town is entering into a private agreement with a business contract to have the land properly maintained, properly trimmed?
This is not a private landowner, this is the town's land.
I understand, but I'm saying by engaging a business to maintain the land, could that not be deemed proprietary?
It could be deemed, if you're hiring somebody to cut the grass at the town hall, that would be a proprietary action by council. And it could extend for a reasonable period of time.
That's right. So
into
how's
the
that
future.
different?
But this, as you pointed out, Your Honor, this contract provides in perpetuity. It is to last forever. And that certainly is not a proprietary function that is appropriate. I might add that, as you pointed out as well, that it says that this contract is binding on the parties, their heirs, their successors, and the signs, clearly making this a contract to last in perpetuity. The agreement also says it may not be modified, it may not be amended, and I continue to quote, except upon the mutual agreement of all parties and their authorized agents. This is clearly an attempt to give private citizens, the named parties, their heirs, their assessors, their successors, and the signs, and their authorized agents, the authority to veto any act that any future council wishes to take with regard to the accredited land. While our Supreme Court has previously ruled that this unlawful veto power is improper, in the Martin versus Clay case, a private sewer system down in Charleston was deeded to the North Charleston Sewer Authority, a public body. That contract provided that the owner of the private sewer system was given the absolute authority to approve or disapprove of anyone who wanted to hook up to that new public sewer system, except for a couple of limited areas like single-family dwellings and so forth. Now, the circuit court held that this was unlawful delegation of power, police powers, to a private citizen. It was against public policy. And the Supreme Court wrote in the strongest language I can remember reading from a Supreme Court decision, this situation is not tolerable. A political body may not delegate to a private party its police powers to approve or disapprove of an act that public body wishes to take. I'll conclude by saying the last part of that opinion, quoting from that opinion. The police power of a political body cannot be exercised for private purposes or for the benefit of individuals or classes. That's exactly what we got in this case. Thank you.
Thank you, sir. Mr. Hood on reply.
Thank you, Your Honor. May it please the court. With respect to the last comment about benefit of classes, I think if you go back and you take a look at the settlement agreement, you'll see in the settlement agreement the findings that the town council made about its own independent assessment and evaluation of what it was doing, why it was doing, and for whose benefit it was being done. It's exercising its own authority in negotiating this and ultimately presenting it to the council, voting on it, and then the resolution speaks for itself. The issue of severability I said I was going to get to, I never got to. So according to the interpretation of the case law in South Carolina at this point, if the court concludes that this is a business function, then you look at whether it can extend beyond the period for town council, and to do so, it needs to be fair, reasonable, necessary, or advantageous. And then in part of that is duration can be considered whether it's reasonable or not. When you look back, actually, at the Cowart case, it talks about 20 years is not reasonable for an employment contract, but it also says while 20 years may be reasonable for other contracts, is not for an employment contract. Now, in Cowart, there was no question. The Court of Appeals concluded and the Supreme Court agreed that that was a government function. And so we're talking about just additional analysis that was being done. But I thought it was important that the court recognize that 20 years for other contracts may be appropriate. And when you think about property and property law and property rights, 20 years, 30 years running with the period of the covenants is reasonable and is appropriate. If the court thinks otherwise, the severability clause gives the court the ability to strike through the third bucket, so to speak, of the work to be done. We have the immediate, we had the within 1 year, and the periodic basis. It doesn't gut anything else out. It's easy to take out. A pencil will do fine. And you might ask, why am I advocating for this? Why if my clients are entitled to something more, would I suggest severability? I've spent so much time over there on that island, I can tell you that once this work is done, the whole community is going to realize we've been fussing and fighting for 15 years over nothing. It's going to be beautiful, it's going to be enhanced, and everyone's going to still be able to enjoy it. And at that moment, I think we will be able to enter a legislative solution. And so I'm comfortable with severability if that's what the court is ultimately inclined to do. The one thing I haven't addressed is the underlying lawsuit. So we had an underlying lawsuit that was remanded back to state court to address the ambiguity in the deed. The settlement agreement resolved that lawsuit. We have no lawsuit now. If this agreement is void ab initio, there has been no consideration. We should be able to go back, reopen our lawsuit, and continue on and have a trial. Otherwise you're able to negotiate something that you're not permitted to negotiate because it's void ab initio, because you're negotiating a governmental function, see if you like it, and then raise it later and then get rid of the lawsuit. It's pretty creative, I guess, if they were that intentional about it, but there's no equity involved with that. And so if their claim is that for now, the maintenance of our property is governmental function, and this settlement is void, we should be permitted to go back, reinstate the case, and let us continue on with our trial to address the identified ambiguity by the Supreme Court. The second aspect of this is, in the underlying litigation, we came up with a solution that provided, a definitive answer for the moment. The town of Sullivan's Island is going to continue to change. It's going to continue to have new town councils. But when you look at how that all impacts this transaction, I can't even begin to distinguish how they could agree to encumber the land so that it could never be developed, to bind future town councils and have certain obligations contained in it. And that's proprietary. But then when we go to enforce it, it's governmental. Anything we're asking is governmental, we can't do anything. You've created an illusory situation that can't be the answer. Otherwise, this case is the roadmap to undo the deed. This case is the roadmap to give up the restrictions and protections of this land that we all agree should be preserved. And so from a conservationist standpoint, where my heart is, I don't want to see that happen. And I don't understand how you could have a scenario where we would encourage conservation, we would do it through property rights, and then we would have maintenance obligations, and we would not allow people to enforce those maintenance obligations. It makes no sense to me whatsoever. And for that reason, we would ask you to reverse and reinstate the settlement. Thank you.
Thank you. Thank you both for your very fine argument. We'll be in recess.
Be upstanding for the court.